Hello everyone, welcome to today's video, which is designed to give you an overview of the new off-payroll rules for both agencies and end clients. And I'll be using some slides to help us navigate through this quite complicated piece of tax legislation. IR35 was originally implemented in the year 2000. It was then, and still is now, aimed only at contractors who work via an intermediary. The most common type is a contractor who works through his or her own limited company or personal services company, and they are generally referred to as PSCs. But IR35 also applies to contractors who work via partnerships or even through other individuals as their intermediary. It's important to remember that IR35 does not apply to PAYE workers or umbrella workers, or indeed even sole traders or other types of self-employed. Instead, there are other pieces of tax legislation which regulate and govern those types of contractors, but it's not the IR35 or the off-payroll rules. The original rules were implemented to stop individuals gaining a tax advantage from working as a PSC contractor if they weren't genuinely self-employed for tax purposes. They are what HMRC refers to as disguised employees. The UK has only two statuses for tax, employed or self-employed. If you are not one, then you are the other. It's a binary situation. Now, IR35 is all about tax. It has nothing to do with employment status for rights. The two regimes are completely separate, even though, unhelpfully, they use the same terminology. If you have an employed status for tax, then income tax and national insurance contributions, both employers and employees, are payable on the total assignment income. If you have a self-employed status for tax, though, a different tax treatment applies. Now, the tax treatment to apply depends on the type of self-employment that you're using, but when you're operating via a PSC, generally most income is taken as dividends, and that results in less tax and no NICs being payable. Now, this in turn means contractors have a higher rate of what we call take-home pay than if they were considered employees for tax purposes. And the difference between being considered employed and self-employed for tax purposes is approximately 20 to 30% of the total pay rate, but can vary considerably depending on individual circumstances. Before 2000, many contractors simply assumed that they were self-employed for tax purposes simply because they were supplying services via their PSC, not as an individual, and they therefore gained a significant tax advantage. When the original rules were implemented, they required PSC contractors to assess their assignments and determine for each assignment whether they were employed or self-employed for tax purposes. If a contractor is genuinely self-employed when operating via a PSC, he or she is considered to be outside IR35. Conversely, if a contractor is employed for tax purposes on a particular assignment, then he or she is inside IR35, and that's the terminology we generally use. So the IR35 rules, the original ones, it made PSCs responsible for determining their own tax status. And if they misclassified their status for any reason, well, that was a matter between the PSC and HMRC. Agencies and end clients had no obligations and no liabilities under the original IR35 rules. In 2017, HMRC decided to change the responsibilities and liabilities relating to IR35 for public authority clients only, and these were called the off-payroll rules. Now, the perceived success of the off-payroll rules in terms of the increased tax and national insurance collected has led to the same regime being extended to the medium and large companies in the private sector. The private sector extension to the off-payroll rules take effect from the 6th of April 2021, and they affect all current and future PSC contractors from that date onwards. The rules will apply to all clients who are public authorities or who are medium or large private sector businesses. Small companies and companies based wholly outside the UK are exempt. I won't explain the exemptions in detail here, as we've got it covered in other content in the IR35 Navigator portal, but if a company is exempt from operating the off-payroll rules, then the individual PSC retains all the liabilities for their IR35 status, just as they do prior to April 2021 in the private sector. Any recruitment agencies who are small are not exempt from the rules. The exemption only applies to end clients. Now, the rules don't change how IR35 status is determined. It changes who must decide status and who must make deductions for tax, if applicable. So the end client, that is, the business who receives the benefit of the PSC's services, they become responsible for determining the tax status for any PSCs they engage, whether that's directly or via a recruitment agency or employment business, as it's often known. Now, this is different from the old rules, where the PSC decided its own tax status. Clients are required to take reasonable care when making IR35 status determinations, and we have some additional materials that give you more detail about reasonable care, so I won't dwell on it here. Suffice to say, though, that clients will be required to show HMRC that they've done everything reasonably possible to assess their PSCs fairly and accurately. Clients are required to communicate their status assessment in the form of a Status Determination Statement, or SDS. As a minimum, the SDS must contain the status outcome, so that is whether the assignment is inside IR35 or outside IR35, and the client's reasons for coming to that conclusion. The SDS must be passed to the worker directly and to any recruitment agency who supplies the PSC, if there is one in the chain. Clients must also implement some form of internal process to allow PSCs or the agencies that supply them to disagree with or challenge their status determination. And if the client doesn't implement a suitable process that fairly determines whether or not the original status was the correct one, well, that could be evidence that it has not taken reasonable care in its assessment process. If a client does all of those things properly and to HMRC's satisfaction, then if there are any recruitment agencies in the supply chain, the responsibilities and liabilities under the off-payroll rules move down the chain once the client's responsibilities are completed. Each agency in the chain is responsible for communicating the SDS to the next agency until we get to the fee payer. Now, the fee payer is the agency that pays the PSC. If there are no agencies in the supply chain and the client contracts directly with the PSC, then the client is the fee payer as well as the client. If an assignment is determined by the client to be outside IR35, then nothing changes. The PSC continues to be paid by the fee payer without any deductions for tax or national insurance. If, however, the assignment is deemed to be inside IR35, then income tax, employees and employers' national insurance is payable on the full assignment income. And deductions need to be made from the PSC before the payment is made. And this is what the legislation calls a deemed direct payment. I won't go into detail today of how that payment is calculated and how it works, but it is quite complicated, so please do take advice. Now, you aren't required as an agency to offer contractors a deemed direct payment option. You can require them to move to an alternative supply arrangement, such as agency PAYE or a PAYE compliant umbrella instead. Now you have a basic understanding of the off-payroll rules from a procedural perspective. The next question is, well, what happens if and when anything goes wrong and someone doesn't comply with their obligations? What happens if an end client hasn't issued a status determination for a PSC contractor, or if it hasn't taken reasonable care in doing the determination? What happens if the fee payer doesn't ensure the correct taxes and national insurance contributions are paid when an assignment is deemed inside IR35? Well, the non-compliant party in the supply chain, whoever that might be, will become liable for paying to HMRC an amount equal to the income tax, the employee's NICs, employer's NICs, and apprenticeship levy, if applicable, that should have been paid to HMRC under that assignment and wasn't. Furthermore, interest on the above amounts may also be payable if the liabilities relate to previous tax years. Now, there aren't any retrospective liabilities under the off-payroll rules, so the liabilities will only relate to the 2021-22 tax year onwards. But HMRC doesn't tend to enforce legislation in the current tax year. They're almost always playing catch-up, which means they generally investigate perceived non-compliance from 4 or more years ago. So just because HMRC doesn't open an inquiry in 2021, that doesn't mean that they can't investigate and hold you liable in later years for what you've done or not done during 2021. And that's when those interest payments start to become more significant. And finally, HMRC can seek to impose additional penalties for non-compliance. There are some circumstances when the liabilities move between parties in the supply chain. And these transfer of liability provisions kick in when one party in the chain, let's say for example the fee payer, doesn't comply with its obligations under the off-payroll rules. HMRC investigates that fee payer only to find that the fee payer company no longer exists. If that happens, well, HMRC can't collect from the fee payer. So they'll use these transfer of liability provisions to hold Agency 1 liable instead. Agency 1 is the agency closest to the client in the contractual chain. If HMRC can't collect from Agency 1, perhaps because Agency 1 liquidates as well, or because Agency 1 was the original fee payer that no longer exists, well, then HMRC is able and may pursue the client. HMRC have also put in place some specific anti-avoidance measures in relation to the off-payroll rules. If any party in the supply chain participates in any way in some kind of tax avoidance arrangement in order to circumvent their off-payroll rules responsibilities, or to retain a similar level of take-home pay for contractors deemed inside IR35, then the TAAR will apply and will seek to recover the unpaid tax and NICs from that party. If multiple parties are involved in the avoidance behaviour or arrangement, well, HMRC will start at the top of the chain, closest to the client, and work its way down in order to recover the debt. This anti-avoidance rule puts a greater burden on both clients and agencies to ensure that where an assignment has been deemed to be inside IR35, whatever model the contractor is engaged on after the 6th of April is compliant. So if you move the contractor to an umbrella model, for example, you need to be absolutely sure that the umbrella is deducting full PAYE. Because if it isn't, and you knew that, and you referred contractors to those arrangements, well, you can be held liable under this targeted anti-avoidance rule. And you will be held liable rather than the umbrella, because HMRC targets the highest in the chain first. My final point to mention is aimed primarily at agencies. We've seen lots of clients trying to offset their liabilities by passing the risk down to agencies in the form of a contractual indemnity. Now, clients can't outsource or flow down their legal liabilities, so HMRC will still hold the client legally responsible if they've not complied with the off-payroll rules. But if you've agreed an indemnity in the client's favour that could be considered to make you liable Even if the liability has arisen due to the fault of the client, then you're the one paying the bill. So make sure you're reviewing all your current and new client contracts and check for any tax-related indemnities in those T's and C's that might come back to bite you. That is a very quick overview of the new rules, but we have lots of other content on the IR35 Navigator portal that gives you more specific details on each of the areas that we've talked about today. Thank you for watching.